After days of intense political war over the Waqf Amendment Act and protests, the Supreme Court gave an interim order on the petitions challenging the act. In an order seen as a victory by both the centre as well as the petitioners, the top court has not stayed the Waqf Act in its entirety, but has stayed some key provisions of the act. In a win for the centre, the court said that laws of the parliament enjoy the presumption of constitutionality and blanket stays are only in the rarest of the rare cases. The bench of Chief Justice of India, B.R. Gavai, and Justice A.J. Masih said no case was made out to stay the whole statute, but some sections need some protection. For now, the court has stayed these provisions. The Supreme Court has curtailed the sweeping powers to the district collector in the new law, observing that it violates the separation of powers. The court said that until tribunal adjudicates the matter, no third-party rights can be created against any party. The 5-year practicing Islam rule is now on hold, which required a person to practice Islam for at least 5 years to create a Waqf. It has been stayed until rules are determined. However, the opposition continues to maintain that the Waqf Act is yet another attempt by the centre to snatch away Waqf property.
Central government, through this Amendment Act, was trying to assert these properties. This is a setback to the central government, and they stand exposed.
ये जो इंटरिम ऑर्डर आया है, इससे जो कानून मोदी सरकार ने बनाया है, मोदी गवर्नमेंट ने बनाया है या एनडीए ने बनाया है, इससे वक्फ प्रॉपर्टीज का तहफ़्फ़ुज़ नहीं होगा, प्रोटेक्शन नहीं होगा और एंक्रोचर्स को रिवॉर्ड किया जाएगा। वक्फ प्रॉपर्टीज में कोई डेवलपमेंट नहीं आएगा।
एक ही मजहब के लोगों को जो है निशाना बनाया जा रहा है। अच्छी बात है कि सुप्रीम कोर्ट ने भी इस चीज को समझा है। हुकूमत का इल्जाम है कि गैर कानूनी तौर जो है किसी वक्फ ने जमीन पे कब्जा किया हुआ है। अब हुकूमत उस जमीन को वापस नहीं ले सकती।
Now, the opposition sticks to its stand, the narrative that the Waqf property is under threat and the government is looking to snatch such property. But the Supreme Court today crushed the ecosystem's narrative point by point, and today let me tell you how multiple such alarmist claims by the opposition was rejected by the Supreme Court. Opposition's demand scrap the entire act, Waqf Amendment. Supreme Court has rejected that demand. Opposition's contention was religious sites will be snatched. Supreme Court has rejected that argument. Opposition's contention was that Waqf by user deletion is arbitrary. Supreme Court has rejected the argument. Opposition's contention was non-Muslims should be allowed to donate. And Supreme Court has rejected the argument. Supreme Court, in fact, has said that this stand taken by the petitioners, in fact, is contradictory to their position. Opposition's contention is that the Waqf property will be usurped by the government. The Supreme Court has rejected that argument as well. In fact, the Supreme Court says earlier Waqf Act was misused to avoid legal hurdles. Now remember, the Supreme Court also stated the 5-year practicing Muslim clause, but the Supreme Court also made it clear that the clause that's added in the new act is anything but arbitrary. So Supreme Court cited possibility of conversion to misuse Waqf laws, cites possibility of conversion for misusing personal laws. Court says 5-year practicing Muslim clause not arbitrary. Why was the clause stayed, you may ask? No method in place to determine one is 5-year practicing Muslim. So Supreme Court says, hence the clause cannot be given effect to at the moment. Centre says clause will be paused until requisite rules are framed. Let's also listen into some reactions.
गहराई से चर्चा करने के बाद उसको खारिज नहीं कर सकता है कि वक्फ अमेंडमेंट एक्ट में जो प्रावधान है वो संपूर्ण रूप से पूरे मुस्लिम कौम के लिए फायदा पहुंचाने वाला है और वक्फ प्रॉपर्टी से जो भी फायदा होगा वो मुस्लिम महिलाओं के लिए, मुस्लिम बच्चों के लिए, यतीम के लिए, जो बेघर है, जो मुसलमानों में भी जो गरीब है, जो पिछड़ा है, उनके लिए काम आने वाला है।
सुप्रीम कोर्ट को किसी भी संसद के कानून की स्क्रूटनी करने का अधिकार है और उसने अपने दृष्टि से जो दूसरी पार्टीज थी उन्होंने, मैंने कहा ना कि जो लूट की लंपट लाबी जो लूट के छूट का लीगल लाइसेंस चाहती है वो उसमें लगी हुई है। लेकिन जहां तक सवाल है कि आज भी हम, अगर आप मुझसे पूछेंगे और देश भी इस बात से संतुष्ट है कि वक्फ के पूरे सिस्टम में जिस तरह की लूट का एक धंधा चल रहा था, उस लूट के धंधे पर जो है वो लगाम लगानी जरूरी थी।
So both sides are claiming that it is a victory for them, it's a vindication for them. Let's open this up and go across to our guests. We have Dr. Kaushal Kant Mishra, spokesperson of the Bharatiya Janata Party, joining us on the broadcast. We have Nikhil Chandwani, author, and Sarfaraz Wani, a lawyer. Let me first go across Sarfaraz Wani. Sarfaraz Wani, petitions were filed objecting to 12 clauses, of which 2 have been stayed and 1 in fact on a temporary basis. The government or the centre claims it's a massive victory for them. It's a vindication of their stand. How do you respond?
Well, key provisions of the law have been stayed by the Supreme Court. In the Parliament, once the debate on the Waqf Act was going on, these were the contentious provisions. These are the provisions where they were saying, look, this is for the welfare of the Muslims. Now, can you yourself decide whether a property is a government property or a Waqf property? The powers under the law were given to the collector, who himself was the party to the dispute. So you are technically allowing a party to the dispute to decide the dispute itself. So that thing is gone. Number second, the 5-year clause which that you have to be a practicing Muslim for 5 years, that is gone.
No, that's not gone. Mr. Wani, that's not gone.
That has been stayed.
Yes, that has been stayed, and the Supreme Court has also said, that it's not arbitrary.
See, understand.
Yes.
The concept of Waqf is I am dedicating something in the path of religion, right? Do I want somebody who doesn't believe my religion, who is not a part of my religion, to decide on that? So this is, in a sense, a clear violation of the rights of the Muslims.
No, how is it a violation? In fact, Mr. Sarfaraz Wani, on two occasions, if you read the judgment copy, twice the court mentions that this is not going to deprive Muslims from practicing their religion. It is not going to do that. So that argument does not hold water. On 2 occasions, those narratives that this is against the Muslim community has been busted.
I have a question for you. Will you allow me to be part of the Ram Mandir body which manages the Ram Mandir?
Which manages a temple, sir? A temple is a religious body. It's connected and related to a religion.
So you will not allow, because I am not a Hindu.
Yes.
That is common sense.
Yes.
Somebody who is not a Hindu cannot manage Ram Mandir, this organization. My point is, if somebody is not a Muslim, why would he be a member?
So what did the court say about inclusion of non-Muslims? No, so Mr. Wani, what did the court say about inclusion of non-Muslims?
As of now, they have limited it, but I think in the final order...
But they have not called it unconstitutional.
This is not an absolute order.
They have not called it arbitrary. In fact, they went by the argument that was given by the Solicitor General that these individuals are only going to look at policy making. The nature of their jobs is secular. So there is no question of interference in religion. The court did not rule it as unconstitutional or arbitrary.
As of now, the interim order. So, at the time of the final disposal of this writ petition, let us see what would be the...
Let me bring in Dr. Kaushal Kant Mishra. Kaushal Kant Mishra, the people part of the opposition are still saying it's a massive vindication for them, an embarrassment for the centre, a slap on the face of the centre, because the court has stayed. It has stayed the 5-year rule, and it has also taken away powers from the collector to have a final word, the final authority. The court says, go to a tribunal and thereafter a high court.
Swati, I think court has opened a big way, because previously even the Waqf order or any rule cannot be challenged in the High Court. Now it can be challenged with the High Court. At least door has been opened, and those who are supporting, those who are against this Waqf Amendment Act, they were trying to basically make it unconstitutional, which is not done by the Supreme Court. So only 2 provisions, and that only one is the temporary provision, in which if the rules are framed, then it can be granted. So only one provision has been stayed by the Supreme Court. Rest whole act has been constitutional. And we have to wait, because this is an interim order. Final order is yet to come. But what the opposition wanted, that this is unconstitutional, whole act should be stayed. Nothing has been done.
No, but how different will the final order be from what has come to fore? How different? Is there going to be a huge difference where the court all of a sudden calls it unconstitutional and arbitrary?
No. I think the power of collector, okay, it is a point of dispute which can be granted or may not be granted. The later period, in my opinion,
because in that particular point, the court has said that there will be a dispute and separation of powers.
Swati, if we go to the Temple Endowment Act, in Temple Endowment Act, the collector is the main person who controls the whole temple, whatever the caste or religion he or she belongs to. In the similar way, the court cannot discriminate between the two religions. My friend was asking, can a Muslim person be the part of any religious body? I can show you n number of example. You can go to the Tirupati Balaji, where many Christians are in the board.
Yes.
Was in the board. You go to the Jwala Devi temple. You go to the Vaishnav Devi temple. Many Muslims are their trustee and party. So was it unconstitutional? No. So if that is not unconstitutional, how we can say that it is unconstitutional if some non-Muslim is going to the Waqf? And Waqf is, for your kind information, it is not an Islamic body.
Absolutely.
It is a managing body.
And that, you know, the role of the members of the Waqf, the fact that it's non-secular, only involves policy making, explains that it's a statutory body. It's got nothing to do with religious practices, Nikhil Chandwani.
Yes, absolutely. I don't know why there is so much of insecurity by the petitioners. The provision to include a non-Muslim or a Hindu member on Waqf board, it has been twisted on social media as interference. And even now I heard the fellow panelist, he said it is something which is not constitutional. But where is the interference? Why is there so much of insecurity? That member, that Hindu member, he will not have any veto power. He has no right to dictate in religious matters. His only role is to ensure transparency. And transparency is something which was missing in the earlier Waqf Act, the Waqf Bill which was there earlier. The transparency is missing, and this person only adds to it. Historically, Waqf Board, it has been misused to claim Hindu properties as Waqf land. It was claimed without any accountability. A neutral member, a non-Muslim member, can simply act as a safeguard. If the intention is pure, why there is so much of insecurity and why there is so much fear of transparency, accountability? It doesn't threaten faith, I feel. It only threatens.
So you're saying those who are opposing are worried and unsettled because of the transparency that it is going to bring and seek accountability. Also, you know, on the issue of registration, the court said it's nothing new. It's been practiced from 1995 to 2013. There is no stay on Waqf by user. The court has also cleared that even if, let's say, these properties fall under the ASI Act, nobody is being stopped from going there and offering their prayers. So how is this against a particular community? How is this going to allow snatching and encroachment of the property? It is not going to apply retrospectively. Both sides are claiming victory. Thank you very much, gentlemen, for joining us on the broadcast.